Just give another copy, please. Give another.
I think
10.
it's a
10.
sliding of copies to the budget.
Yes.
Bullets, I would, in fact, in a sense, take off from where Mr. Kapil Sibal had reached before your lordships. Bullets, I just urge your lordships to consider, the lordship may recall, during the Vietnam War movement in the United States of America, there was a famous trial called the Chicago 7 trial, your lordship may recall. Bullets, there is something there that is the lesson for us. Bullets, essentially, nobody can dispute that if there's a law that you disagree with, you have a right to protest. Peacefully, of course, but you have a right to protest. Where is the line to be drawn, my lords? That's very critical. Your lordship will just keep that in mind. Where is the line to be drawn? If somebody is protesting peacefully and is provoked, and he reacts, to make that into a large, horrendous crime, my lords, is the issue. Of course, nobody is justified under any circumstances to indulge in violence. And what I'm submitting to your lordships is on behalf of Shafiur Rahman, who was the head of the Alumni Association of Jamia Millia Islamia. All I'm saying is that his name may appear anywhere. Totality of the evidence, nowhere has anybody said that he indulged in violence or he did something that was patently unlawful. Because that's the critical thing that is in this note. So, well, I'll take your lordship very quickly. Well, before the FIR 59, which Mr. Kapil Sibal mentioned, is an FIR comprehensively taking every other FIR into account and putting everybody under the umbrella of a larger conspiracy. So whoever has done anything wrong is accountable in a particular FIR at a particular time. But now generally casting the net wide and saying you may or may not be in any violent act, etc., but you are...
This alumni association refers to the past students, is it?
Well, it's past students, alumni, past students. And well, there was an incident in Jamia. If your lordships may just note this. There was an incident in Jamia before these riots happened. These riots happened in February, around the February 22nd. But in December, there was an incident in Jamia in which the police marched into the university and ransacked the university without permission from any of the authorities in the university. Whereas that matter is still pending in the High Court. There are claims and counterclaims on both sides. It's still pending in the High Court. Even then, he was not involved in any act of violence, although he was there on the scene. He was there in Jamia Millia campus, but he was not involved. So your lordship would just look at the first page. Well, the first thing is that he's the president of the organization called AJMI, AAJMI. There are other members of the AJMI organization. Whatever decisions were taken, to the extent that they were taken, were collective decisions. None of those people have been included in the FIR. Your lordship will see the bottom there, last paragraph. Even in the present case, it is interesting to note that the entire AJMI organization is not made an accused. So there was a secretary, there was a treasurer, there were other members of the AJMI organization. Nobody has been included. Just he has been handpicked, cherry-picked, and made an accused in this matter. Your lordship will see on the next page, on the second page, we made it very, very clear, my lords, and I join my colleagues in saying that nothing under the UPA Act is made out in any of the allegations, even if we go at this stage to accept all allegations to be true. And my lords, at no stage have I done anything to delay the trial. I have done nothing to delay the trial. Lordship will quickly look at the background of the person, beginning at bottom of page 2. He is in student politics. He has fought for local body elections. He treats Jamia Millia Islamia as his, not just his alma mater, but as his home. He did his schooling from this very place. And this is where he continues to serve. And my lords, when the bottom of page 3, your lordship will see, when the DPSG, Delhi Protest Support Group, was formed, he was not a member of that group. When the WhatsApp group was formed, he was not a member of that group at all. And then, of course, Malod, if you'll see on the next page, if Lordship will see, he certainly was involved in meetings to support any people who were taking part in the protest. But nobody has said thus far that he supported them in a manner which was unlawful or unacceptable. Then, my lords, at the bottom of page 4, your lordship will see the backdrop was, of course, the CA and RC agitations. A press release was immediately issued by Ajmi, which was dated 21/12/2019, against collection of any money in the name of Ajmi, and the press releases appealed by Ajmi and the registration of Ajmi forms, etc., which form part of the charge sheet. So it's all from the charge sheet. We are not saying something which is new. Then your lordship will come to page 5. And this is again from the charge sheet. Your lordship will see the underscored portion. The piece of evidence that forms part of the charge sheet indicates that the petitioner was not allowed to speak or have a say in the WhatsApp groups by other admins, since no former student was allowed to chair the meeting of the Jamia Coordination Committee. So he would, as a member of the Alumnus Association, he was included in the Jamia Coordination Committee, but he was not allowed to either chair that committee or he was not allowed to speak. This comes from the charge sheet itself. Malas, I've included the annexures and the pages as far as the charge sheet and the paper book is concerned. Then, my lords, there are he was arrested. He was arrested, and when he was arrested on the 26th, my lords, there were only 2 statements against him. Your lordship will just turn just briefly to page 11. Well, I put all the statements against him, including the protected witnesses. I've put the summary of that here at page 11, 12, and 13. These first 2 statements by Beta and Hector, these are 2 statements which were there before he was arrested on 26/4/20. Your lordship will see Beta says, I started to go to the protest daily, where I have seen some students of the alumni of local leaders, etc., so-and-so, and local leader, in which Ashu Khan and Muhammad Asif and some other persons hatched a plan. Now, they were all present in the protest movements. Nobody can deny that. They were part of the protest movement. Hector then, my lords, on 19/4, just before he's arrested. Thereafter, on 17/12, Safura Zargar, who's already got bail, then Pinjrator and so on and so forth, and Ajmi had formed the JCC, the Jamia Coordination Committee, which I just mentioned to you, in which Miran Haider from RJD, Asif Iqbal Tana, and Abu Darda from DISC, Ariba Hassan, Shafiur Rahman, and Badri Alam of Ajmi were present. So I was only present. No allegation that I was present and I provoked or I made even a provocative speech. Well, it's not even that. And then, my lord, subsequently, all the other witnesses that I've summarized here, nowhere in any of these witnesses has anybody said that he's done anything illegal. My lords, the maximum that can be said about him, if your lordship will return briefly to page 5. I underscored again that there were other people in these groups that were supporting the protesters, etc. There were other people also. They've not been distinguished, and why they have not been included in these charge sheets, etc. My lords, it's for the prosecution to answer. My lords, the period of custody, your lordship will see page 6. That's for everybody. The period of custody is 5 years, 6 months. That's for everybody. Voluminous records, you'll also have been told 20 to 30,000 pages, 750 FIRs, etc., and all will have to be looked into, and the number of witnesses, etc. Well, your lordships have already been read out, section 15, section 2 of the UPA Act, etc. Already given the public witnesses, my lords. Then, my lords, at page 7, the issue of parity. Well, there's 2 things here. The issue of parity, which your lordships will find the parity chart is at page 143, 148. If nothing else on parity, I'm entitled to get bail. So are many others, but certainly I'm entitled to get bail on parity. because my case is a fortiori. Whatever the grounds were for the bail that been granted to 3 people, those grounds are more strongly available as far as my case is concerned. Well, the statements under 161 that I have mentioned,
You are claiming parity on what is the basis or along with whom?
along with the 3 who've been granted bail by the High Court, but your Lordship said can be considered only for parity. It will not be treated as a precedent because the High Court had made a very prolonged, very detailed judgment about UAP applies in this case or doesn't apply in this case. Your Lordships had put a stay on that, not to be treated as a precedent, but in subsequent order, your Lordship said it be only taken for purposes of parity. And my Lords, if your Lordships would want to see at page 143, don't want to just detain your Lordship, but at page 143 of the paper boat, your Lordship will find my arguments on parity. As I said, I stand on a fortiori grounds to get parity. Well, of the allegations that have been made, your Lordship looking at page 143, I can just...
The item numbers 61.4. 61.3 or 61?
4, 61.4. Shafiur Rahman. Well, let's say this is Shifaur Rahman is exactly how it's pronounced. Shifaur Rahman. This is Shifaur Rahman.
Page number 143.
143, Mullah, the parity chart is given.
That's right.
And these are the 3 people who are on bail. Your Lordships sustained their bail, didn't cancel their bail. But your Lordships have said that the judgment will not be treated as a precedent in these matters because this is not an appropriate length of judgment for granting of bail and so on. So, but on parity, my lord, these grounds are all very clear. Your Lordship will see page 143, 144, 145, all the way to 148, top of 148.
Yes.
Lordship, I'd like me to read through them, but those are very clear. Well, it's just simple reading is very clear. Parity is established. Well, in all fairness to your Lordships, I have to say that in the counter at page 129, there's a mention that Ajmi, not Shifaur Rahman himself, but Ajmi, he can have obviously indirect responsibility.
In page number?
At page 129 of the counter, there's a statement of one person called Musab, who's a printer. In other words, Musab says that my bill book was taken by Ajmi persons and it was returned to me with an extra bill of 64,000. In other words, there's a discrepancy in various places about what this amount is, but the amount is 64,000. Just that there is, in the bill book, a bill has been added to 64,000, nothing else. This is the maximum allegation that there is against these persons. There's no explanation also how giving an extra bill of 64,000 prevents anything from happening or helps the Ajmi people to do anything which is unlawful and not unacceptable. But it was important that I point out this to your Lordships. Then, my Lords, there is one argument which is to be found, my Lords, at page 8, which is an allegation of his having attended a meeting on the 22nd of February, just at around the time when the riots have happened. This is the second paragraph, allegations of attending meeting on 22nd, because the prosecution relies on the statement of protected witness bond, since bond is an person attending the meeting. For the state to the meeting was saying that it was secret and witness bond knew discreetly that a secret meeting was being held. The witness bond does not single out the petitioner and uses the word Ajmi office bearers. So Ajmi office bearers are present and therefore it's taken that I am present and that I may have been present, but have I said anything? Have I participated? Have I contributed anything? My Lords, is very critical at this point of time. Then, my Lords, there are some phone calls. It's important. And I need to include, I need to disclose that at page 134 of the counter. Your Lordship will just look at page 134 of the counter. The number of calls are clearly mentioned. These calls happen around the time that there was unrest in Jamia and
Page
subsequent.
134, is it?
134, please. Because in fairness, I'm disclosing whatever there is against me. And I'm saying that despite all this being against me,
Is it with reference to that statement of the witness bond?
that's right, Police. And Malaj, the CDR analysis is being done here. Who all I have called how many times? Miran Heather, I have called 34 times. Safura, who's on bail, I've called 3 times. Parvez Ahmed, I've called once. Amanullah, I've called 17 times. This is about that same time when there was a huge lot of agitation, disturbance, and distress around in the December time.
Since Miran Haider has been granted bail.
Because Miran Heather, he's appearing, my learned friend is appearing for you. Well, the discrepancy about the amounts that have been alleged have risen because Miran Heather has some answering to give on amounts gathered, and I have something. For me, there is only a mention of 1 lakh and a mention of 64,000. That's about all. Although by mistake, some places they've put a larger figure, etc., but that is very clear. If your lordship will see now just one important factor. Although I've given all the judgments, your lordship already had several compilations, but I'll give a set of compilations as well. And there's only one recent judgment of the Honorable Supreme Court that I need to point out, which is Karim alias Saddam versus State by NIA, SLP number 11626.
It is not in the compilation already given.
Although it's I think it's been because it was mentioned by my Kapil Sibal, but this in my compilation.
Salim Malik alias Munna.
No, this is Karim versus Karim and Saddam. In this compilation, your lordship will see it in the last page.
This is the one.
The 3 other
Courtmaster is there.
One of the compilation is here.
there are the other earlier 2 compilations which have been given. Kapil Sibal, it is here. The other two given by
More or less the same judgments.
that is right, Singhi and
So if your lordship will see my compilation.
Siddhartha Dave.
One this.
Correct. Yes, one more here.
So just here.
There's one more. Siddhartha Dave also has given. You are not given compilation. I gave. The principle, it is here.
Well, it's page 322. Mr. Sibal had mentioned this, I believe, during his arguments.
Yes, sir.
Well, if your lordship will see page 322, Karim alias Saddam versus State of the National Investigating Agency. Paragraph 4 is very critical because it indicates that this could be done even after charges are framed. Paragraph 4, we have perused the charges framed. The appellants have been under incarceration for more than 5 years. There are 254 witnesses to be examined. The appellants are 2 amongst 138 accused persons.
I think Kapil has given.
Well, this was given by Mr. Kapil Sibal, this judgment. This judgment was indicated.
Yes, sir.
And lastly, you just have to.
Yes, it has been given. Page 171. Follow.
So just lastly, one important fact before your lordships, that's on page 1. In the 4th paragraph on page 1 of my note. He's had the benefit of interim bail on 2 occasions. And he's dutifully surrendered when he's required to do so.
You are referring to page?
Page 1 of the note, brothers. page 1 and paragraph 4. He was allowed an interim bail by special court additional session judge on 25/11/2023 and 11/11/2024, and he surrendered duly on time. And Malus, there is no case, as my learned friend had just argued, there is no other case, and he's not been accused of anything else.
So he's accused only in this.
Accused only in this, only one of the many people who were in the organization. He is an alumni chief.
But he's also accused in FIR 242 of 2008.
No, Mullah, it's not in 240. He's not accused. In fact, he's not accused in 242. When he would have been on the scene, he would have been locally available, but he's not been accused there.
Okay.
So if anything had to happen in terms of violence, he would have participated there when Jamia was being attacked at his own offices within the Jamia complex, etc. But nothing of that kind happened at all. So, Mullah, same length of time, 5 years, 5 years and 6 months. Mullah, I beseech your lordships that in view of our lessons that we learned from Chicago 7, Mullah, this is a case in which your lordship
We
will.
will not go to Chicago.
It does.
We'll be in India only.
Mullah, there are many movements in India. I could have mentioned.
Because if you go to Chicago, it pertains to USA.
Well,
USA has done communities.
I understand. But Mullah, there are protests that have happened in
They
the
have come
region.
to where Russia, Pakistan searched for XYZ.
Mullah, I understand. There are.
So we'll not go for.
There are protests that have happened in South Asia, but we don't even want to go there because each one has its own context, each one has its own flavor. But all we are saying is, Mullahs, that we've always been told that the Gandhian method is that if there's an unjust law, it is your moral obligation to not obey the law and to defy the law, which is what the Satyagraha of the Salt March was. So the law needs to be broken, but not with violence. That is all. Well, that your lordship will keep in mind. Deeply life of us.
Literally devils quoting scriptures.
If direct to appear in 61.2 for a person called Miran Haider. I have a short note for your lordship's facility that was emailed last night, but we'll apply more copies if
It's 61.2.
2 minutes. I have a request of your lordships. Since I bring up the rear of the batsmen who have come and faced your lordships, could your lordships start with the impugned order?
He's not pinch hitter. He's not pinch hitter. That's why.
Right. I'm beholden to it and thankful to Mr. Sibal for recognizing at least some spot and some role, other than just filling the numbers.
Yeah, what did he say?
Okay.
Is that?
You want us to look into the improved order.
Mr. Sibal called me a pinch hitter. Please have the impugned judgment, which begins on at page 1. And the structured words of the impugned judgment your lordships will find. Please come to first page 39. What the Honorable High Court did was to categorize all of us as accused persons who were under trial seeking bail into different categories on the basis of what the Honorable High Court felt were parities, inter-se parities between us. So we understand that all of us are standing here seeking the same amount of time before the prosecution begins its submissions. But within us, the Honorable High Court's order recognized that there is some inter-se parity and people are to be treated differently. Please have that first, page 39. And initially, at the foot of the page, paragraph 53. So the first set of two people that the Honorable High Court's judgment dealt with were Sharjeel Imam and Umar Khalid, para 53. At the outset, we would like to note that based on the prosecution's narrative, the appellant Sharjeel Imam and Umar Khalid have been ascribed the role of having played a central and key part in the alleged criminal conspiracy by organizing, coordinating and inciting masses to protest, which escalated into violence, communal unrest in various places in Delhi, leading up to the large-scale February 20 Delhi riots. Therefore, for the sake of convenience and given their attributed role, which appear to stand on the same footing, we deem it appropriate to decide their appeals.
You are
together.
representing Miran Haider.
I bow down. So now this is the first set. The second set, your lordships will find at page 73. What is common to all of us will be the length of incarceration and the delay and the process that has been followed so far. What will be distinct is the prosecution's allegations, narrative, and material against us. And that second part, which is in after 5.5 years, how much that tail will wag the dog is the seminal question. But in order to demonstrate that, because that's the distinction that each one of us brings, otherwise the issue of delay is the same. Somebody is arrested 5 years, 6 months, I am arrested 5 years, 7 months, somebody is a little lesser. Those aspects, we don't have to trouble your lordships over and over again. Now please have page 73.
Yes.
4 other persons, Athar Khan, Shadab Ahmed, Abdul Khalid Saifi, and Mohammad Salim Khan are dealt with as the second category. Para 151 deals with the fact that these are now category 1, category 2. And I, am placed by the Honorable High Court at page 100 in the third category, with a person called Shifaur Rahman, for whom Mr. Khurshid just concluded his submission. Page 100, foot of the page, para 230. Over the page, page 101, second line. We may thus proceed to note that the role ascribed by the prosecution to the present appellants Shifaur Rahman and Miran Haider, which are intrinsically connected, therefore it is appropriate to deal with these two appeals together. But your lordships will come to the findings against me, because this is something which I wish to place. Page 116.
Page 116.
116. I will begin at 117, paragraph 283. We have perused the aforesaid statements and the material placed on record. It is the case of the prosecution that the appellants, here it refers to the two of us, played the role assigned to them in furtherance of the alleged larger conspiracy, managing various protest sites across Delhi, allegedly attended various meetings of the JCC at the Ajmi office and other venues. Appellants were allegedly part of a WhatsApp group which were created to have organized protests, alleged to be responsible for disruptive chakka jams. Appellants have been alleged to have raised and collected funds to be used in riots. This raising and collecting funds is important because that will become one of the prime reasons to deny me bail, and I have to deal with that. Please come at 118, paragraph 288. Appellant Miran Haider is stated to have given money to Ajmi where the meetings of JCC were held, when appellant Shifaur Rahman, being the president, played a pivotal role. And just the sentence above that, prima facie, it appears that the appellants were working together. Allegation of funding is a serious factor which cannot be brushed aside.
288, is it?
I am requesting your lordships to look at 287, last sentence.
Friends were working closely together.
I bow down. And the allegation of funding is a serious factor which cannot be brushed aside at this stage. Appellant Miran Haider is stated to have given money to Ajmi where the meeting of JCC was held, where the appellant Shifaur Rahman, being the president, played a pivotal role. But this issue of allegation, I'll just open that key a little bit. According to the prosecution, 1.6 crores was the amount spent in order to organize and fund these riots. Insofar as I am concerned, the allegation was that I received 80,000 rupees in my bank account. Please contextualize this with that 1.6 crores. On cash, they say I got 4.5 lakh rupees, out of which 2.5 lakh rupees is still lying with me. 2 lakh rupees is, according to them, the contribution, the serious contribution that I have made to this. There are answers to that within the material, etc. But when we balance the rights of the accused and the prosecution in the context of a 5-year, 7-month incarceration, we are looking at an allegation saying, at best, taken at face value, that somebody paid 2 lakh rupees out of a 1.6 crore mechanism to organize these riots. And that is how central my role is. And I will show what they say about me. They have been a little kind to me, and I'll place them. Could your lordship then come to para 292, because this is important. One of the issues that all of us have dealt with is the issue of parity. Your lordships asked a question to Mr. Khurshid, what is this parity? Please note that 3 accused persons, 2 ladies and 1 gentleman, were granted bail by a detailed judgment of the Honorable Delhi High Court in the year 2021. Same matter, same conspirators, 3 persons. One of them, I had the privilege of assisting the court for the gentleman, Asif Iqbal Tana, was represented by me before the Honorable High Court. The Honorable High Court, after going into the entire charge sheets, threadbare analysis, gave bail on multiple assessments, including the falsity or the, let's say, the weaknesses in the prosecution case. That bail was challenged
For three accused.
for 3 accused persons. 2 of them were ladies.
This is order.
Judgment of the Honorable Delhi High Court dated 15th of June 2021. 4 years ago.
15/6/2021.
4 years ago. And these 3 persons were granted bail on merits. Obviously on their merits, but also having the context of the larger prosecution merit or the lack thereof. This judgment was challenged before this Honorable Court.
Yes.
And at the initial stage, while issuing notice, this Honorable Court said that this judgment will not be considered as a precedent. That interim order is of no relevance today because finally this Honorable Court upheld that bail. Those 3 persons who were granted bail on 15th of June 21 were never taken back into custody, continued on bail and still are on bail.
Subsequently, the SLP was dismissed.
SLP was dismissed.
While retaining that it would not be a precedent.
I'm sure, sir.
Yes,
I'm
no,
sure,
you
sir.
said it
I'm
doesn't.
sure, sir, that I'll be able to,
Yes, you
I'll
say
be
that.
able to competently and obviously to the best of my ability assist the court. And if I lose it and if I don't point out something, I'm sure the prosecution will. But please don't. Page 310 of my SLP paper book, Annexure P4 is the order passed by this court. I will not place words in it, I'll just read it out. At 311. May I place that there? The impugned order. Your Lordship says 311. The impugned order is an extremely elaborate order of bail interpreting various provisions of the UAPA Act. In our view, the only issue which is required to be examined in such matters is whether in the factual scenario an accused is entitled to bail or not. It is this argument which persuaded us while issuing notice on 18th of June 21 to observe that the impugned judgment cannot be treated as a precedent and may not be relied upon by any of the parties in any other proceedings. The idea was to protect the state against the use of the judgment on enunciation of the law qua interpretation of the provisions of the UAPA Act in a bail matter. Respondents have been on bail now for almost 2 years. We see no purpose in keeping these matters alive. We may notice that one of the co-accused has filed an application seeking in a way to interpret our interim directions of 18th of June 21 and submitting that the said observations were coming in the way of seeking bail. The applicant is a co-accused. If the co-accused is entitled to a plea of parity, that is for him to make and the court to consider. We want to make it clear at the cost of repetition that the purpose of interim order of 18th of June 21 was that the expounded legal position regarding the statutory interpretations in a bail matter should not be utilized in proceedings either of co-accused person or any other person or any other matter. With the aforesaid clarification in the interim directions, dated 18th of June are met for final directions in the matter. On having noticed the aforesaid, we close the present proceedings. SLPs, etc. are disposed of. So, in a nutshell, I'm not relying on either the enunciation of the law or, for that matter, the weaknesses of the prosecution case as pointed out by the Honorable Delhi High Court in its judgment. It need not go there. What is important is the fact that three persons, having some role ascribed to them, being made an accused, were granted bail. That bail was upheld. The time period for them to be on bail 2021, we are today in 2025. We raised this issue of parity before the Honorable High Court. Despite this order of your lordship, please see what the Honorable High Court does for the issue of parity. Go on me, and I'm not interested in everybody else in this line. Ultimately, each one of us has to swing or stand on the basis of either the collective issue of delay or our individual merits. Please have paragraph 292, page 119. On the plea of parity as raised by the appellants, conspiracy on the plea of parity as raised by the appellants, we are of the view that the position and role of the present appellants in the alleged conspiracy is placed differently than the co-accused persons in the entire sequence of events, allegedly being one of the fundraisers in the conspiracy that would warrant the benefit of parity to be extended to them. Further, we have dilated on the plea of parity with the co-accused granted bail by this court in foregoing paragraphs of this judgment in extenso, and the same may not be reiterated. The plea of parity is not made out. In fact, what was argued was, yes, there is a difference between me and them. My role is actually much better, is much lighter, is much lower. The Honorable High Court was on, and that's where this issue of fundraising comes again. With this in mind, please have my note. And I'll quickly now run through my note, since your lordships have seen what has weighed with the.
Yes.
Your lordships have my note.
Yes.
I've just handed over. Lordship. December 2019, as a fallout of the introduction of the CAA bill in the parliament, protests were held across the country, including at Delhi. As per the prosecution's case, there was an overall conspiracy to effect a regime change, which has been categorized in four phases, because I provided the relevant page where this is the overall case that they had put up. Incidents of violence took place in December 2019 and February 2020, which gave rise to approximately 751 distinct FIRs in Delhi. On 6th of March 2020, the present FIR 59 was registered to investigate the larger and the overall conspiracy regarding the protests and the riots. Offences under the IPC, the Arms Act, UAPA and the PDPP were invoked during investigation. I was arrested on 1st of April 2020. So as on date, I have now finished 5 years and 7 months and a couple of days. Respondent has filed charge sheets and supplementary charge sheets on 16 September 20, 22nd November 20, 1st March 21, 2nd March 22, and 7th June 23. Total 18 accused persons arraigned. Please note this, the next part. So the last charge sheet that has been filed is as of June 23. And even in that charge sheet, it is said that my investigation is still going on. When it comes, Milords, to the next progress of trial or the next stage of trial, which will be the issue of determination of whether charges are to be framed or not, it presupposes, as the first seminal part, that your investigation is over. It can't be a scenario where accused persons are called upon to disclose their, not necessarily their defense, but point out the lacunas in your case, but your investigation is continuing so that it can keep on filling it up as time goes by. This clarity. So as of 17th of June 23, the clarity on written record by the prosecution was, no doubt I have filed 4 or 5 charge sheets. I am still investigating and you are entitled to. While I languish in jail from April of 2020 till this June of 23, please conduct your investigation, no difficulty. After this, please see para 5. During the course of the above, some of the accused sought clarity from the prosecution as to whether the investigation qua then was complete. or not, since the arguments on charge could commence only after completion of investigation. It was on 4th September 24, basis the written submissions filed by the respondent on 28th of August 24, that the learned trial court noted that the investigation qua all the charge sheeted accused was concluded. No, this will be a line in the sand, is my submission. The question of any delay caused at the instance of any of us on this side cannot be looked at prior to the prosecution taking onus and responsibility for its investigation to say, yes, my investigation is over, I am ready to move to the next phase. That date is 4th of September 24. Order sheets will be placed before your lordships to say, yes, charges were being looked at, but some of the accused were pushing us, were telling us, no, you please clarify whether your investigation is over. That is not delay. That is an assertion of my right to know whether your investigation is in fact concluded or not, so that I can open my case before the learned trial. This date, the 4th of September 24, the order sheet is on record. Please see then para 6. Accordingly, arguments on charge commenced on 5th of September 24. Since commencement, they have been going on with dates being given at short intervals. As on date, 12 accused persons have argued charge. So within the next 12 months, this has happened. Till date, the petitioner has been released from custody once by order dated 24th of August 24 for a period of 10 days. I had suffered a bereavement in the family. The trial court was kind enough to grant me interim bail. I took that opportunity. I was released on bail. I did not go and tamper with evidence. I did not look at any protected, unprotected, or any other witness or document. I surrendered in time. I did not raise any threat to the prosecution case. Because if I was to look at usual bail considerations, please come to page 2. I am 34 years of age. I have done certain degrees which I have noted. During my custody, I am also pursuing my PhD. It's 5.7 years, I've already said. Third point, prosecution has now admitted that the investigation qua me is over. I am languishing in custody exclusively in this case. There is one more case which I have pointed out at para 5. I am not a habitual offender. I have only one other FIR, which is related to these protests, which is FIR 289. He is on bail because they did not need my arrest. They did not seek my custody. They filed a charge sheet without my arrest. I was summoned by the court. I was granted bail in that matter, and I am pursuing my appearing in that.
The FIR 289, you are granted regular bail.
Granted regular bail because they not only the fact, one thing is to say that they took my custody and then I was granted regular bail. My conduct was such that their investigation could be concluded without needing me in custody. My presence at large was not threatening either their witnesses or their case. They were able to conclude their, so what was filed was a charge sheet without my arrest. And then on that basis, in line with what your lordships have said in until and other judgments, on appearance, I was granted bail. The record of this case, para 6, will show that the trial will take time. There are 960 cited witnesses, 1214 relied upon documents. I'll pause here for a moment. But these are witnesses cited not by me, and definitely no court is telling them how to do their investigation. Their investigation of this 5 years, 6 years compelled them to say there are 960 important people we want to place. When the accused seek bail, citing the fact that you have cited 960 witnesses, their counter affidavit now says, no, the accused are raising a bogey that these are 960 witnesses. In fact, we will prune them down to 150. So why did we cite? The prosecution finishes 5 charge sheets, uses the fact that I am continuing investigation in order to deny bail to the accused persons for the last 5 years. When your investigation is over, 960 witnesses are cited and you are called to take responsibility for that. No, I only need 150. This double standards will not be allowed to continue is my submission. If you have cited 960, you want to do 150, you want to do 250, that's up to you. Even the choice of citing 960 witnesses was a choice made by the prosecution. And it must be held accountable for that. But let me assume you will try 150 witnesses. Are we assuming charges will be framed? Are we assuming that the trial is going to start tomorrow? There are 7 more people who still have to conclude on charges, if framed, 150 witnesses to be examined. This is, if I was here before your lordships in the year 2019, 2020, 2021, I could have understood your lordship saying that it is too premature, let them get some time. that prospect, in my humble submission today, after 5.5 years, any length of time for 150 witnesses is a length of time which is one day too many.
Out of these 150 witnesses, that includes the protected witnesses.
I assume so. I have no idea what.
They are not stated anything.
But
The counter nothing.
the counter says I will be able to reduce it down to 100, 150. What formula I will use, which methodology, I have no idea, and they will not definitely ask me. Please have the point number 7. For multiple offences, and I have placed a chart, your lordships may not see it. For many of the sentences, as on date, as an under trial, I have either completed the maximum sentence or 50% of the sentence which is prescribed for those offences. If that is the position, and this is where, because in matters like this, when we say as an agency that no persons are not entitled to bail, the onus is on you. Then you must demonstrate the fact that you are giving me a fair trial and an early trial. It cannot be that I will continue investigations ad infinitum. I will have delays that are going on. Accused will spend time as under trial, serve out sentences. The trial is irrelevant, will be made redundant. Now, please see below my third section, which is on parity. Whereas I have placed at 349, if your lordships don't mind, please look at my SLP paper book, a chart placing on record what was the prosecution allegation qua the persons who got bail and what is the allegation qua me.
So Natasha and Devaganga.
So Natasha and Devangana were two ladies who had gotten bail. This chart at 349 is a distinction between the role ascribed to me and the role ascribed to them. That they were members in the core group called the DPSG. Both of them were there, not me. Member of a group called Pinjra Tod, they were there, I was not me. Member of Warriors, they were there, I was not me. Member of group called Auraton Ka Inqilab, they were there, I was not there. Members of the JCC, they were there. I am also alleged to be there. I have placed some pointers there as to why that is irrelevant for me, but please leave that aside. Point number 6, setting up of participating in protest sites, same allegation. Attending an impugned meeting of 23rd of January 20, which according to them is a conspiratorial meeting. Allegation against them, not against me. Point number 8, a secret meeting at Chandbagh protest site on 16th and 17th of February 2020, alleged against them, not against me. This is 5 days before the riots. Distribution and use of dandas, bottles, chili powder, acid, stones, allegation against them, no allegation against me. So these are details, but the purpose of this exercise before the Honorable High Court, which has taken a significant time in dealing with these bail applications, was to demonstrate that I am not worse off. And that was the test of parity. The High Court does not indicate on what basis does it say I was worse off. The only indication is, the issue of fundraising is a secret issue, is a serious issue against you. On that, please come.
So these two have been granted bail.
These two granted bail. Please have page 352. 352, the next page of my SLP paper book. The third person who was granted bail was a man called Asif Iqbal Tanha. Against him, allegations was member of his.
These two, this is Natasha and Devangana.
Natasha and Devangana granted bail. The allegations I have noted and I have made a chart. The reason why I treated them differently was because sometimes we anticipate an argument that look here, they are entitled to a special consideration on account of the fact that they are.
Where does your written note show that these two persons have been granted bail?
Because my written note at page 2, section 3, where it calls out parity, calls to these pages at 349 to 355. Your lordships are right. I should have put the relevant order.
No, at least in sentence that these two have been granted bail.
Because I'm sorry,
If it is not there, we want to take note of that. That is what.
Page 2, section 3. petitioner's case on parity, your Lordship may just note there, this is parity with these three persons.
All right,
And that's why it's referred, page 349 to 355 are referred.
correct. But
I should have made that clearer. Just please note that this is parity with Devangana, Natasha, and Asif.
no, you have just referred to page 349.
I apologize. I should have made it.
You have to know whether anywhere it reflects that these two have been granted bail. It doesn't say so.
But in the note, it does not say so. The relevant order, the High Court judgment, I have not paid 310. Your Lordship saw that order. Page 310 of my SLP paperwork is the order of this Honorable Court declining to interfere with the state's challenge.
With respect of these two.
These three.
All
These three.
all.
I pointed that out, but the three of them
These
have
three.
been granted.
It is for these three persons.
Natasha and Devangana have been granted state.
These are the bail clauses which were granted in June 21, upheld by your
It is a common order.
by a common judgment before the Honorable High Court and a common order before your Page 310, your Lordships will find the SLP numbers as well. 4289, 4288, and 4287.
Here only one name is seen.
So your Lordships will then after see that three with SLP criminal 4288 and 4287.
So the High Court has different orders. SLP is common order.
Page number 428.
Page number 310.
Correct.
Your Lordship, the first
What I'm saying
SLP
is in the cost title of this order,
is Devangana's name.
only Devangana's.
Please have the line after that
Ah,
with SLP criminal 4288.
The problem here is they don't write the name.
Names. Lordships are right. Names are not there, but impugned judgment, and I'll indicate that. Impugned judgment, paragraph 142, page 69.
All right. We take it that it is not in dispute. But
So that's it. Para 142, page 69. Refers to precisely this.
all right.
Let's please have then page 3. Now I've tried to build own. My submission below your Lordship's consideration is that after 5.5 years, whether merit scrutiny is required or not, and as to how much merit scrutiny is required, at some point in time, your Lordships have held that the balance gets tilted. Whether that time has come today or not, I can't be presumptuous. So in order to satisfy your Lordship's judicial conscience, I have made a table with reference to what is the allegation against me. I will only deal with 2 of them, because those are demonstrable issues which in my humble submission should shock the conscience of the court. Please have page 3. The second line on top, charge sheet alleges, and I've quoted the charge sheet, that accused Miran Heather deserves a separate mention, being one of the only 2 charge-sheeted persons who have been arrested exclusively in this case. In no other case relating to the riots beginning from December 2019 onwards did his name figure. Thus, had it not been this case, the role played by this accused might have gone totally unnoticed, and then goes on to make that allegation. Your Lordships will just see the table, and please see the topic is financing, page 3. Allegation is that the total sum used in the riots is 1.6 crores. It is alleged that he received 5.63 lakhs from various sources for riots. Out of this, 2.33 lakhs was recovered from his house. 2.86 lakhs is alleged as used for riots. Out of the 1.66 crores, his alleged contribution of 2.86 lakhs would be less than 2%. Despite this, the impugned judgment erroneously refers to him as a key fundraiser. The paltry sum available with him was explained fully because of his upcoming election campaign, personal expenses for his mother's death and father's health issues, providing food supplies to protest sites. No finding was returned of the above. Nothing on record to show that any money belonging to him was used in the financing of the riots. Petitioner is not in the list of donors of Ajmi, which is alleged to have funded the riots. No, they actually made a list. They very kindly made a list saying who all had donated to this alumni association of Jamia Millia. Allegation made against me, but that list does not have my name. So all of this, I am sure I'll point out before the court at the stage of charge. Please have page 4. But this is that point number 2, Lordship may see it. Allegation is that I am in conspiracy with gentleman Sharjeel Imam, who's also here before it. I have a tweet in public saying that this gentleman Sharjeel Imam should not be allowed to come into any of the protest sites. If he comes there, he should be thrown out. Yet there is a conspiracy charge against me with the said person, and the allegation is, oh, this Twitter, that the public post that I had made was to mislead the actual position. The fact that I went to a police station after the riots, so during the course of riots, I went as part of a delegation to the police headquarters asking the police to please intervene. That is now said as this is only a cover-up. We have no difficulty. We'll deal with all these allegations. But if a person goes to a police station, that is a conspiratorial act. If he indulges in rioting, it's a conspiratorial act. If he does protest, that's a conspiratorial act. That, Munaz, is at point number 3, the last column. Allegation is only made on the basis that the petitioner received 2 calls from the co-accused Umar Khalid on 24th of February, after which he played victim and travelled to the Delhi police headquarters and asked the Delhi government to organize a press conference. It is submitted that if the petitioner had presumed any kind of threat, it would have been him calling the co-accused person and not vice versa. It is conjectural to say that a person approaching the police or a government agency is an inference for him having committed an offence. The last page, brother, and I'll quickly run through the bullet points on item 4 on the issue of rioting. Not present on any of the rioting sites, no recovery of any weapon, no CCTV footage against me, no still images, not the state's case that I was part of the 2 secret meetings that were held at Chandbagh and Seelampur. Please have point number 5. Allegation is, and this is in the counter affidavit filed before your lordships, that on 13th of December 2019, I did something at Delhi, physically. Whereas consistently from the very beginning, I have told them and I have given them material to show that from 4th of December till 14th of December, I was in Bihar because my mother had passed away. I am not even in Delhi. Now these issues, your lordships are not going to evaluate at the stage of bail, but these issues definitely show that the accused here are not people who have no case and should be presumed to be guilty in that context and be kept in custody till the time the investigation is over and the trial court finds it convenient to hold that. Page 54 of the reply, I'll end with this. Please have page 54 of the reply before your lordships.
One second. Counter.
Of the counter.
Page number?
Page number 54, 54, paragraph 95.
On 8/12/2019.
I am most obliged. 8/12/2019, a meeting
One
at,
second.
I'm so sorry. Paragraph 95. On 8th of December 2019, a meeting at 6x6 Jangpura, Bhogal, New Delhi was organized by Yogendra Yadav, attended by Umar Khalid, Nadeem Khan, Sharjeel Imam, Tahira Daud, Khalid Saifi, Meera and Haider, and others. There was an allegation made against me before your lordships in the counter affidavit. Please turn over the page. This is not an actual photograph of the meeting. This is a pictorial representation. One would have thought that Delhi police knew how they were sitting, but this is so that it stays in our minds a little bit better. But please have page 55. There's a table, there are chairs, there are people on those chairs, and there are names given to those people, but I am not there. Paragraph 95 names me. The next page, the picture does not have me. And I am...
This picture is by the...
This is part of the charge sheet. Part of the charge sheet, also part of the counter affidavit before your lordships. The caption below the photograph, your lordships will find photo of meeting at.
Oh, it's an actual photograph. It's an actual photograph.
No, photograph is actual.
Ah, that is,
It's part of the charge sheet.
you are saying that is,
No, I'm saying.
It's not an AI generated photo.
No, no.
It's an actual photo.
The names on top, your lordships will find.
you are not figuring that.
I'm not
But
figuring.
you gave an impression that it's not an actual
No,
photo.
no,
Yes.
issue-
Inadvertently, must be.
I'm so sorry. The issue is, page 54, para 95, the prosecution makes an allegation in the counter affidavit against me that I am part of this meeting. At page 55, it places
So
the.
it is as simple as, according to this, the photograph produced by the prosecution itself does not reflect your presence.
That is one. 4th December to 14th December, 8th December included, I am in Bihar attending to the last rites of my mother. Could not have been in this meeting, was not in this meeting. This allegation, according to me, subject to correction, is not even part of the charge sheet.
No, in the initial stage, we thought this is a photo made by them, not taken out at the actual place.
No, the names,
Normally
etc.
the names.
Names, etc. given on top are given by the prosecution as part of the charge sheet. So I am submitting this. It is kind allegation such as this.
It's not a sketch, it's a real.
It's not a sketch.
It's a real photo.
It's not a
Only
sketch.
the person who clicked the photo is not in the photo.
We get that impression it is a sketch.
It's not a. So from my point of view,
It's not a selfie.
unless the allegation will be that I took the photograph, because that's the other way I.
The only person who has taken the photo is not in the photo. That's all.
All I was saying was, this is a meeting that has been invoked by them. I am not even in the city, but my name is put there. All of these are issues on merits which some trial court will deal with at some point in time.
So this photograph refers to, according to the prosecution, 8/12/2019.
I am obliged. I am obliged. Hence, Philip, my submission, and I rest with that, is whether on the issues of delay and 21 or on the issues of merits. This apparent, Philip, in my humble submission, deserves to be admitted to me. To clarify, Lordships have noted one last point on that. This allegation, which is at page 54, para 95, the same allegation with the same set of names is in the charge sheet at page 2020. My name does not figure in the charge sheet.
All these persons who are shown in the, depicted in the photo, have been charge sheeted?
No,
All.
no.
Who have been left?
Out of these, I am given to understand that only Mr. Sharjeel Imam and Umar Khalid are accused persons as on date.
Oh.
The others are not charged sheeted.
Somewhere one name comes Ibrahim Hussain. What is happening to him?
I'm so sorry.
One of the accused, somewhere I read Ibrahim Hussain. What is happening to that?
Tahir Hussain.
Tahir Hussain.
Tahir Hussain. What is happening to that accused?
He is in custody, he is in jail.
So
In three different bands.
that last point with your lordship should just note that page 54, para 95, the allegation is the same as page 2020 of the charge sheet, except my name is not in the charge sheet on that allegation. It is in the counter affidavit before your lordship. Same photograph, same paragraph. My name is not in the charge sheet at page 2020. 2021 is this photograph of the charge sheet. In the counter affidavit before your lordship, my name is there. Those are my submissions.
Oh,
I'm okay.
Wait, please, Madam. I beg to appear in item 61.5 on behalf of Mohammad Salim Khan. Plus, we've also prepared a short note, and I'll attempt not to repeat any arguments.
you are the last batsman.
Yes, my lords, tail ender.
There's one matter, Shadab Ahmed, which is fresh. Which is fresh, which is listed today for the first time. That I understand my friends would your lordship take it today, or would they
You have issued notice.
notice the response?
What?
So item number, fresh SLP,
61,
I think it's a fresh
60,
matter.
60, it's a fresh one.
It's a fresh matter.
we have issued the notice.
When would your lordship keep it?
You have already issued
I
notice.
don't know, when would your
No,
lordship?
but notice is not issued.
Notice
It's
was
a
not
fresh
issued.
matter.
Today we issued.
Acha,
Your lordship
2 days.
indicated that. I'm not very clear about when your lordship will keep it for. Because they would like to respond, I'm sure.
We'll file a counter.
See what we told your colleague.
Yes.
He said tag. Your colleague was present.
I understand what he was saying.
60 years. We said we don't know whether they may say they will file counter or they may say already we adopt the counter already filed.
That's the issue, that's the stand they'll have to do.
For them to, until and unless they see the paper, how can they say?
Yes,
I understand.
We don't have the papers.
It's one of the accused in the same batch, same batch.
No, everyone has a different glorious role.
Sorry?
Everyone has a different role. I'll tell you the adjective afterwards.
The adjectives. My learned friend is liberal with his adjectives, but fortunately not for us.
Not for you.
Yes, that's it. There are 151 onwards, and the role is, his role, he's dealt with along with Akhtar Khan.
You are at this 61.5.
No, no, I'm in 16. So my lord may just give me a date, not whatever is telling you.
Let us see. Let him complete.
All right, I will.
I will be served the copy of that.
I just checked it. You served the copy? You served the copy?
The solicitor kindly look into it and tell us
We will.
whether if you adopt the same this thing,
We will examine and
or if you want to supplement or say something more.
We just serve it to your junior right now, whichever.
So my colleague, yes, you can give a copy right now. Another.
Go and give it to the gentleman.
Yes, sir.
Yes, my lords.
You are
Plus,
good.
by way of my lords, Gautam Khazanchi.
Gautam?
Khazanchi, my lord. Plus,
Yes.
by way of background, I am a permanent resident of an area of New Delhi called Chandbagh. This is one of the areas which was
Before we proceed, all except one, all of them are from Delhi, correct? Only one person is from Bihar. He is in item number 61.
Plus, Chandbagh was one of the areas which was affected by the riots. I have been residing there since 1992 with my children. Plus, my antecedents only arise from these set of cases which involve the Delhi riots. If your lordships will have paragraph 3, there's a table I have extracted.
The 3 FIRs.
Yes, my lords. First, I was arrested on 11th of March 2020 in FIR 60 of 2020 PS Dayalpur. While I was in custody, after a period of 2.5 months, I was arrested in the present FIR on 25th of June. Thereafter, 5 months thereafter, I was formally arrested in FIR 136 of 20. Your Lordships will also note on the right side, as far as the other two FIRs are concerned, I am on bail. Plus, before I deal with the specific allegations, in this there are particular features which I wish to highlight, qua me in particular. Your Lordship will take it that I am not a member of any organization, formal, informal, whether it's Pinjra Tod, United Against Hate, any other organization. Your Lordship will note that I am actually not even a member of any WhatsApp group on which the prosecution relies upon in their entire charge sheet, whether it be DPSG, JCC, MSJ. I have not sent a single message to any of the alleged main co-conspirators. Then your Lordships may note that there is not even a single speech, let alone any inflammatory speech for me, no allegation of terrorist funding, no arms and ammunition recovered from me, and definitely no victim who has come forth and said that I have acted in any violence with them. Plus, my primary role, your Lordships will see in para 8, arises from being one of the main organizers, that is the allegation, of the Chandbagh protest site, and in that capacity, I am alleged to have attended certain meetings. Those meetings your Lordships will see at paragraph 9. Paragraph 9, your Lordships will see the first set of meetings on 16th, 17th and 21st. Plus, will appreciate my presence in these meetings is established by a statement of witnesses recorded 2 months after my arrest. As regards the meeting on 22nd February, it is 1 year after my arrest that a witness comes forth and says I was present at that meeting. Plus, secondly, with respect to that meeting, the prosecution actually relies on CCTV footage. In that CCTV footage, there are various persons, I am not there. Plus, that belies that allegation on the face of it. Then your Lordship will have the third meeting. My lords, same reasoning, 9 months later, I am implicated, CCTV available, not there. Plus, the other allegation, and this is crucial in the sense of, because the Honorable High Court, while dismissing my bail application, relies on this allegation. The allegation is that I am seen in a CCTV using a wiper to turn away a camera, to dislocate. Plus, this was the very same allegation in FIR 60, pressed by the state, dealt with in my bail application by the Honorable High Court, and considered. If your Lordship will have the extracted portion at para 10, the Honorable High Court categorically notes the allegation and states that this allegation by itself is not sufficient to prolong my custody. And my lords, this order was passed as far back as September 2021. Lastly, there is a fundamental aspect which perhaps I can distinguish myself a little further. Your Lordships have heard various senior counsels say that their client has been released on interim bail. Plus, please consider this person who has been released on interim bail not once. Once was in 2023, 3 times in 2024, 2 times in 2025. That's a total of 6 times as on date. Each and every time.
2023, 2024, 3 times.
Yes, Malas, I'll just pass on those orders as well. Malas,
Don't bother.
Malas, I've extracted them in the table. Malas,
which table? Which
yes, Malas. Paragraph 13, if your Lordships will have. 2 weeks in 2023, 2 weeks in 2024 June, thereafter 10 days in July 24, 10 days in December 24, 10 days in March 23, and 10 days recently in October 25. Malas, my respectful submission in this regard is, this person, Malas, has demonstrated before your Lordships that he satisfies the triple test, that he has surrendered on each occasion, he has never taken an extension. He is not a flight risk. And if your Lordship will see all the reasons for the purpose why this indulgence has been granted to my client by the learned trial court or by the High Court is for the welfare of his children. So admittedly, he has deep roots in society. Unless such a person, in my respectful submission, is definitely not a
not yet performed your daughter's marriage.
Unless it is next week. Unless which I will be applying for interim bail before the trial court, because that is the procedure, Malas, in these type of cases.
Oh.
I have 2 daughters and a son.
So you have taken wise bail for them.
Malas, that was the engagement.
Engagement,
Malas, last year, and then Malas. In fact, Malas, the trial court has been kind to me, if your Lordship. That's why I wanted to pass on the order. The first order, notes that my conduct is not only satisfactory in jail, but it is satisfactory in court. And that is why the indulgence is granted to me. Plus, lastly, malas on delay and parity, malas enough malas has been said by learned senior counsels before me, so I will not belabor on that point. But your lordship may take it that, as far as I am concerned, the same principles apply. I have my bail application also took 3 years in the High Court before 3 separate benches. I have also been in custody over 5 years. And on parity malas at page 147 of my SLP malas, I have put out a chart. The argument being that those who have been granted bail have a much graver role than I.
Where is that? chart?
Malas page 147 of the SLP.
in this
Malas,
note-
that's in the SLP.
In note you are not.
Malas, I'm sorry, Malas. In the note, that page number is missing. It's 147. That chart is in the SLP.
Where do you say about parity in Kumar?
Malas, page 4, part E, paragraphs 18.
This refers to page number 143, is it?
147, Malas, of the paper book. Malas, this would be ground O.
It is extracted in the.
Well, this would be page 147. Ground O, there is a table. On the left side is the person who has been granted bail.
You extracted in your SLP.
Yes, ma'am. So the role assigned to each accused who has been granted bail I have extracted, and my role I have already shown your lordships that I have participated in meeting. My respectful submission in this regard is the role ascribed to these persons who have been granted bail is much more graver than the role ascribed to me. That is my humble submission. That's all.
Mr. Luthra can complete his submissions. If we need to give any additional note on facts, we'll give them.
You're in 60, no?
Yes,
60.
16.
60.
But I had mentioned that 345 is a specially fixed matter, my lord, of mine.
Lord, that's my, I'm also there, my lord. If your lordships can pardon our absence and put for
Solicitor, if you want,
pardon our.
before you start the next year, and meanwhile, you can also find out whether there's something, and I'll do it that day. I have no difficulty.
Certainly.
Whatever is still.
How much time you have?
15 minutes, 15 minutes, 15, 20.
Let him complete, my lord, by 4 o'clock. My
I may take a little longer, so I'll go through still 15, 20 minutes broadly.
Then,
The day you
Take
start,
notes,
I'll
he'll
start.
take
you will be here.
Yes, yes.
You will be here.
Yes.
And the next date, my lord, your lordships could be keeping it on.
When? Tomorrow? Day after tomorrow?
Day after tomorrow.
Day after,
Tomorrow
Thursday.
is a specially fixed matter of mine at 2 o'clock.
Thursday, we have listed 2 matters.
So Wednesday is a close, it's a holiday. It's a Guru
Wednesday's
Purab.
holiday, not this time.
Guru Purab.
Okay. Guru Nanak's.
Hmm?
Sixth we'll see. Sixth we'll say at 2 o'clock.
6 days off.
Sixth, so many matters, yes. Sixth, so many.
Barabar, sir, pardon. No, kindly pardon
There
our
are
absence.
2 part-head matters we have listed on 6th. One is the Air India crash.
Yes, your lordships are hearing that.
Almost
84,
still they are grouping in the dark to get some compensation.
yes.
Where 125 people or 126.
No, 136.
Out of them, 4,
4 survived, and in very out of the 4,
2 died.
3 died.
3.
Only 1 survived. One of the persons, my lord, was our colleague's brother. Sonal Vasavada was a lawyer. Her brother was one of the survivors. He died after 2 months because of septicemia in the hospital.
One gentleman just walked away. As a
No,
miracle.
not this one.
One person walked away as a miracle.
That is recent one.
That's it.
The court is hearing 84.
Oh, you're hearing the 84.
Who?
Yeah.
Vasavada is the lawyer.
Sonal Vasavada was a lawyer. Now she is in US. She was practicing with.
We'll see in case this collapses, we'll take up.
6 not.
Huh?
6.
Otherwise, If the market matter goes on, we will not be able to accommodate.
I'll take my
Then
chance at 6.
We'll have it on next Monday,
Sir,
right?
sir,
17th.
10th, not 10th. Monday will be 10th.
It is as old as I am.
But Lord, what we'll do is,
That litigation. That suit was filed before I was born.
but what we'll do is we'll check with the learned courtmaster at 1 o'clock on the 6th. If it is possible, fine.
No.
I know, but we'll check at 1 what the position
Yes.
for 4 days. We'll check at 1 what the position of the board is. That will be better.
Really strong. Right, she's also all those
Good.
senior reports. All these 3 persons.
Yeah.
Kapil, Sibal, Uspe, and so on. Including Siddharth.
So the copy.
There are 2 Siddharths. What is Siddharth?
So 4.
No, today,
Today there are 3, not there Siddharth Dave also.
Siddharth Dave, Siddharth Luthra.
Yes.
Who is another third
Siddharth Agarwal.
Siddharth Agarwal.
And then he was the one who argued, not the one who is lesser here than me.
No, the honor remains Siddharth. Honor remains Siddharth. Nobody has become Gautam as yet.
No, but we did have a Gautam, Lord. We had a Gautam arguing, Gautam Khazanchi arguing.
Yes, sir. Siddharth followed by Gautam.
We are acting as Gautam.
There is one missing Siddharth Bhatnagar. He's not in this batch. Fortunately, he's not here.
That's right. Thursday.
Oblate.
Great.
Thursday 6th, no?
6th.
6th.
Okay.
For further hearing.
Good.
Oblate.
All.
It's 59 first one only appear. Item 59. Item 59.
Lordship, in this matter, it is admitted case of the prosecution that the taxi
First,
driver.
we will thank you for coming, sir, for the 4th time.
I'm sorry,
No.
I am very
We
sorry.
are thankful for you to have come and argued the case.
I was confused due to 61 Lordship.
Huh?
I was sitting outside the court, my Lordship.
Sitting outside, all.
Lord-
59.
Lordship, in fact,
Item number 59, is it?
Yes.
What is the stage of the trial?
Lordship, it has commenced, Lordship, but he is behind the bar since 2.5 years, Lordship. But in fact, I was the passenger of that taxi driver. In fact, taxi driver stopped the vehicle and ran away by taking the. I said because I was the passenger, but something was found in the taxi itself, Lordship. I have no role, no any transaction, nothing, Lordship. Why I have been convicted? Because it is a taxi, Lordship. It is not a private vehicle, Lordship. I was sitting because I was passenger of the taxi, Lordship. And admitted case is that he took a left turn and ran away, driver. I remain sitting that he will come. And something was found in a bag which was in the taxi itself.
How many witnesses are there?
Lordship, list of witnesses not available at this stage, Lordship.
Sure. Charge sheet, it will be available, sir. What is this here for? How many witnesses? You said 14 witnesses have been examined.
Lordship, witnesses have been
How
examined.
many witnesses are there totally in all?
Lordship, I have not run next the charge sheet, Lordship, but in fact, my involvement is not there.
Where is the charge sheet?
I may place on the court, Lordship, next.
Huh?
I will place on the court, Lordship. That's it. I may be granted time. Lordship, in fact, my involvement is not there. I was a passenger, Lordship.
Huh?
I was passenger, Lordship. So it is a taxi, Lordship, not a private vehicle, Lordship. And
Correct, sir. To appreciate your argument, should we not have the charge sheet?
in fact, Lordship, I could not. I will place, Lordship. Within my place.
From FIR, what do you get it? What do they say in the FIR?
They are saying same thing, Lordship. I have next that driver took the left turn and dropped himself from the taxi and ran away, Lordship. It is at page, Lordship, page 26, Lordship. That car driver, on seeing the police party on the road, turned the car towards left side of the road and got down from the car and ran towards the back side. When rushed towards the car along with SC official, I saw another person sitting in the front seat of the car and a bag was there.
Where was this bag?
This was on that car, Lordship.
Where?
Lordship, that was obviously front of my seat, Lordship. But in fact, it was.
I saw another person was sitting in the front seat of the car and he had kept a bag between his legs. You were having that?
No,
1.23.
It was not my bag. In fact, Lordship, because what was kept, it was of the taxi driver itself. Otherwise, I had run first, Lordship. I had run first, Lordship. Because if I had some suspicion.
No, you have been lazy. Probably you would have been dozed off.
Obviously, because driver was knowing something that what he has kept in the taxi. Then he ran away without telling me that something of that nature. How? Because I cannot do anything. What is his belongings were there, Lordship? Because
how many years you are inside?
I was as a passenger inside, Lordship.
From how many years you are inside, sir?
2 years. Two years and 6 months, Lordship. Since July, I am 2 years and 6 months, Lordship.
You are issuing notice, sir. Not you have a good case, sir, because you have not made out a case. To ascertain what is your case, we'll ask the others.
I will write, Lordship. I will also prepare.
We're also obliged.
I will prepare, Lordship. Next time.
In 6 weeks. Yes, permitted to serve the standing council. Yes, next.
Item 29.
Please, it's compassionate appointment. The High Court has directed that you appoint the respondent on the.
Rules as it was prevalent then.
And not on the rules. The problem, the
2022 is.
factual problem I'll state before my lords. After the death of the employee, it came to knowledge that he had a first wife and another daughter who had also filed for compassionate appointment. Now, my lords, we came.
They are not before the court.
My lords, they are not, but that she's writing to us, my lords, as late as September 25, that I also, because the first one.
Who is she?
Well, her name, first wife is Annapurna Das and the daughter is Shubha Lakshmi Das. And actually, well, as per Hindu marriage, she is the first wife. The second wife, whose daughter is now before my lords, she, my lords, is also writing. So both the daughters are now writing for the compassionate appointment. Now, the second daughter from the second wife, we had done an elaborate assessment. They are not in that much financial hardship. They have a house of their own. Plus, the mother is also has a pensionable service, my lords. So she is receiving a pension. The problem.
This court in Canara Bank they said pension should not be counted.
That's okay, my lords. But why the point system? My lords, kindly see the eligibility is there in Annexure P1. What does the eligibility say? That we have to see who's more indigent, who requires the financial assistance. So when, my lords, in a particular.
On that ground, you have not rejected.
No, my lords, we have rejected that on the point system. Now, what is point system, my lords?
The postal department.
No, my lords, income tax office. He was the deceased was senior tax assistant officer. Well, if there are 100 people, I ask myself, there has to be some criteria where we will ascertain who deserves the compassionate appointment more. Now, this point system is nothing else but where we compare different people and whether who's the most indigent of them, who requires the financial assistance the most. That is the only criteria. Kindly see the detailed discussion, my lords. And now, when there are two daughters asking for it, well, it's our problem as a department is she's also a legitimate child. How do we give it to the second one when the first one is probably the firstborn also? Because till the employee was alive, the second wife and the daughter also did not knew this fact. Now we have a legal heir certificate also, which mentions both the daughters.
So the last 9 candidates you selected for that year. So the last candidate got 39 points.
Yes.
Right?
So he was more indigent. He required the financial
You are
assistance.
giving it to him.
Yes.
Right?
Yes.
Now she has been awarded 27 points.
Yes.
Right?
Yes.
Now between 27 and 39, how many are there? Where do you say so?
The list is not.
The reason is this. If we had said, suppose we give it to her 27, the junior person who is at 29 or 28 or 31 or up to 36 or 38 would be eligible.
May I read? This is what it means. Because
This is not what it means. What you meant is not what transpired is important. It's a case of compassion.
The point, the problem, from the department, I have that application from the other daughter as well. Now, and that wife, the first wife, she does not have a pension. She probably, that daughter needs more. So today we don't know.
Don't shed crocodile tears.
No, that's not the case. We have to give
Did she pursue her grievance? Did she?
But she's writing to us continuously. I have the letter.
Probably you would have taken 10 letters signed by her and you kept it every month. You are releasing one letter. We don't know.
Please don't say that.
We don't know. These are things. These are all
it would.
Postal Department, Customs and Judicial Excise, Central Excise, Income Tax, day in and day out. I have depended on last. I know.
Compassionate appointment is not a right. You have to show that you are indigent. You require the financial assistance.
It is very
rarely. See the eligibility.
Very rarely the courts grant extended compassion.
Absolutely.
Yes, where it has been extended by two courts.
She's been considered. The direction is that you appoint. That has to be considered, Can I just have, let me just say these.
You should notice, for the limited purpose of examining as to whether the High Court, under the impugned order, could have directed the grant of employment, or it could have only restricted a mandamus to the employer to consider the prayer of the applicant for being appointed on compassionate grounds. Question mark. You should notice. Only for the limited purpose.
I bow down, my lords.
That to show the problem marks.
I'll also produce that list where there were people above her, and therefore, my lords, I have to get that from the
We do not want the type of list. We want the photocopy of the original. This is central excise, correct?
No, this is
which department?
Income tax, senior tax assistant officer.
If it is income
tax office.
If it is income tax, which division? Because that division officers will not seek for compassionate appointment. Personally speaking, I know.
Central Board of Direct Taxes, madam.
No, it will not be CBDT. If it is south, it will be east. If it is east, it will be north.
Well, I will come back.
Officers will be different. They come and sit because the purpose is so that they will not have any prejudices.
I quite see that.
They maintain a double register of double size. We want photocopy of that.
Well, let's know more than me. Well, I'll seek the.
I was at the receiving end.
I'll have that. Well, there's a contempt petition pending to appoint.
Contempt is first.
Yes, no, I see.
Proceeding stand state.
I'm encouraged.
Item 30.
Lords, I beg to appear on behalf of the petitioner. This is a case where my appointment as a regular employee of the university has been quashed and set aside. And inter alia, the single judge has relied on a Wikipedia definition of industrial
Rightly so.
My lords, I may just point out to the UGC notification, 18 July 2018. My lords may come to page 54 and 56, which say that for recruitment as assistant professor, page 54 and 56.
MSc Agriculture Biotechnology and MSc Biotechnology.
Yes, my lords.
20?
Lords, page 54 and 56.
One second.
Sorry.
Page number?
Page 54 is where the notification starts. I am relying at clause 4.0, direct recruitment, at page 56, bottom. Page 56, bottom, my lords. Direct recruitment for the discipline of art, commerce, humanities, etc., sciences.
56.
56, yes, my lords.
Qualification.
Direct recruitment, rule 4.0. At the bottom of the page.
Correct, directly.
Yes, my lords. Assistant professor, eligibility. A master's degree with 55% marks or an equivalent grade in a point scale where the grading system is followed in a concerned, relevant or allied subject from an Indian
What
university.
is that you are reading, 55?
My lords, this is the UGC notification. Sorry.
How does you import UGC, sir? Now come to see UGC maybe.
Yes, my lords.
Now that UGC equivalent should have been accepted by the employer.
Yes, my lords.
As simple as that.
Yes.
We'll use, last time also we gave this illustration. Suppose they want to appoint for the Supreme Court, law clerks.
Yes.
They will say, we want 5-year LLB. Merely because we have also passed LLB, X has passed LLB, if they have passed 3 years, that may be equivalent to practice as an advocate. But that is not the requirement of the employer. Employer wants only 5 years. So here the employer says, MSc Agricultural Biotechnology.
It says MSc in the concerned discipline. Discipline.
Advertisement, please.
Yes, my lords, yes. The advertisement. 8th March 2019 is the advertisement. It's Annexure P10. Annexure P10.
No, which page?
Page 112, 112.
Relevant page is 114.
Yes, my lords.
Serial number 9.
Yes, my lords. That's the
Assistant
post.
professor.
Yes.
Correct.
No, 116.
No, please come to 114.
117.
Before we go to 117
Yes.
later on.
Yes, my lords.
Read it. What is this? Name of the
says-
post?
Name of the
CCTV?
post is Assistant Professor or Equivalent.
Huh?
Or Equivalent.
Equivalent.
Yes. my lords.
Agricultural
Bio-
biotechnology.
Is the discipline.
So it should be an equivalent to agricultural biotechnology. Yours is what you possess is agriculture. You possess
MSc Biotechnology.
only biotechnology.
Yes, that's admitted.
These are the marked differences between biotechnology and agriculture.
My lords, I agree. But my degree of biotechnology.
It is entirely different subjects.
My lords, just a minute. May I just submit? May I just submit? My lords, my degree of biotechnology is from a state agricultural university.
From X, Y, Z, or in university or
Lords,
whatever.
my degree in biotechnology is from a University of Horticulture and Forestry.
Neither it is the job of the courts nor the job of the employer to substitute its view to that of the employer. Employer says, I want MSc Agriculture Biotechnology. You may be possessing a better qualification. But they do not want that. They want only that.
May I just say that the employer has supported my case and said that there is no violation of any rule in his appointment.
That is why the division bench has said no.
No,
They said selection committee has no right.
because they've said that the selection committee has no right to take an equivalent certificate. That's what they've said.
Only redeeming factor is you are given one promotion.
I've been regularized.
Regularized, one promotion, and you have put in 4 years, 4 months.
4 years. And my lords, my appeal is pending. I'm just against the refusal of state.
Without salary.
My lords, I'll take instructions. I'll take instructions.
So tomorrow you might say that equities are in my favor or this.
My lords, as of now, I'm the sole earning member. For 4 years, I've been serving.
See, sometimes, Mr. Counsel, we know where to exercise sympathy and where not to. Many a time, sympathy will not go hand in hand with equities. What to do?
But may I just submit? There's no malafide against any expert.
We are not saying malafide.
Yes, Mr. And may I just submit one small thing? When I did my MSc Biotechnology, because it's a state accredited agricultural university, and I had a simple BSc degree, they asked me to do deficiency courses to come at par with other students. The university where I've done my biotechnology says that I've done certain deficiency courses.
We'll tell you one more reason. What they prescribed is MSc
in concerned discipline.
Agricultural Biotechnology. This is what the advertisement, page 140. This is what is published in the newspaper.
May you read this with page 117?
It can't be. So now what happens is, we'll tell you, there may be a candidate who is having higher percentage than what you have, and he might or she might not have applied. For the obvious reason, they would have seen the advertisement and said, it shows MSc Agricultural Biotechnology. Since I only possess biotechnology, let me not apply.
I agree. But there were 31 other people like me.
If the selection committee says, no, we will also consider MSc Agricultural Biotechnology, or biotechnology equivalent to agriculture biotechnology, it means changing the rules of the game after the game has commenced.
May I just?
That is impermissible under the service jurisdiction.
I agree, Manoj. There's a 5-judge bench decision against me of November 2024, Tej Prakash versus
Take
Astana.
instructions as to whether you would not claim equities. If so, you file an affidavit, you consider whether you can continue to work and you'll be paid salary on the day of, suppose we don't accept your package. Then you will not be able to claim any equities.
So grateful. But Piloj, may I just point out that the appeal is pending before the division bench. I'm against the rejection of stay. So if they just protect me for that. I think my lords was the impression that this
Emotional, emotional.
No, so sorry. We've served for around 4 years, my lords, and there was no stay in favor of the writ petitioner during the petition. And may I just point out, the panel remains alive for 1 year. His recruitment has happened after 1 year. So that may be a separate case for us, but the writ petitioner has been appointed. The
Suppose he has become age bound.
The writ petitioner?
Yes.
I'm not aware.
So now it is one pitted against other.
It may balance it at the appropriate stage.
Balancing, that is, it should be a person who not doctrine of impari delicto. We'll see, all right. Issue notice. Interim stay.
So grateful, so grateful, so grateful.
Stay of the include order. A petitioner is permitted to take out notice on the standing council within 1 week from today and file an acknowledgement. Failure to file the acknowledgement would result in automatic vacation of the interim stay grant.
So very grateful.
So, the rest of the matter next month. Anything urgent? Any urgent matters?
My lords,
Yes, madam.
Lords, may I mention item 36? I'm only seeking for the interim order to be continued as exemption from surrender has been allowed only till this date.
All right. Wherever there is interim order, it will be extended. Automatically. Next Monday, remaining matters will be reviewed. That is.
Similarly, in item 40, there was an exemption from surrendering.
Item number?
40. In item 40, there was an exemption from surrendering till the matter is taken up for hearing. So that may be continued. Item 40. Mrs. Anjari had granted that. Please to grant.
Interim order to continue.
Or item
Item
number,
40.
item 55, my lord. May I request to next week, my lord. Next week, there is some difficulty.
50?
55. I'm in 55.2.
There's a letter, 55.
I have circulated, my lord, because today we have received the documents, my lord. Records.
4 weeks, Lord. Agent for 4 weeks.
4 weeks. 4 weeks.
Very good. Grateful. Interim order to continue.
Interim order to continue.
Grateful.
Who is in 41? 41? Anybody there?
Item 41?
42?
Yes, Lordship, I am appearing in 40.
42.
Yes, Lordship, 19-year sentence is going to be completed. Lordship, 20 years the sentence award.
Issue notice returnable in 4 weeks.
I'm grateful, Lordship. Highly grateful.
Item 34?
Item 34?
32. I appear for the petitioner in 34. I'm
Yes.
appointed by the Learned Supreme Court Legal Services Committee. My lord, there is a delay of 4,140 days in this matter. And there was a similar petition filed by co-accused. However, the roles which were accorded were different. And my case is that the best case that the prosecution has against me is that
You are not eligible in the state of Punjab for this remission policy is not in vogue.
My lord, about that I'm not aware because she has already undergone around 18 years and
That's
2
what,
months.
18 years, 2 months, 2 days.
Yes, my lord. Up to April this year, that was 18 years, 2 months and 2 days.
Whether Punjab there is no such.
There is some policy, but I'm not aware of. Haryana and Punjab, they have almost similar policy. Generally, after 15, 16 years, they are released.
This is only single solitary murder.
My lord, and the allegation against me is that I only hit the daughter with a broomstick and held her hand.
Not broomstick, stick. Not broomstick.
My lord, there is a distinction. Against the brother, there is an allegation that he hit her with a washerman's glove. But against the mother, that is me, this is the only allegation.
What is returnable in 4 weeks?
Much of.
Both on issue of delay and main mind.
Lord, in item 45, can it be Friday, Lord?
No, you have asked for, you gave the letter? No, 55.
45.
45, okay. 45 we have adjourned it, 55 we have adjourned it, 45.
45, I am requesting for Friday, Lord. Possible.
It is only an interim order.
I know, no, it's not interim order. It's final order.
That is cooling towers.
Yes, yes.
Ah,
It's final order. It has been remanded back to the trial court.
correct. So we will tell the trial court without being influenced by the observations made. Only para 22. That's all. Maximum we can do to say para 20, not to be influenced by para 21 and 22.
I'm requesting because I'm led by Mr. Nagamuthum.
Oh.
So let it be on Friday.
Then we'll be dismissing it. Friday.
Good night.
So there is a delay of 2,350
On next Monday. Post it on next Monday. Coming Monday. 45. All right.
Monday.
45.
500 delay.
Ma'am.
1,353